Feel quite heard on behalf of International Independent Holdings Ltd and others and Allianz Insurance Plc.
Thank you. Mr. Doherty.
Yes, Linda, I was just going to clarify one thing I said yesterday
Right.
in the context of my submissions on the policing authority question.
Yes.
And in relation to the judge's finding that it referred to authorities enforcing the law or ensuring that it's obeyed. And I said that the focus below had been on police cordons, etc., and not so much on this question of enforcement. I just wanted to clarify that the question of fire brigades was raised, and in particular, one of the points made by Mr. Gruder below was giving the example of a fire brigade closing a theatre, very much in the context of directing, ordering the submissions we've heard. What my submissions remains, however, to be clear, the focus, certainly, and I'll be correct if I'm wrong, was not on the question as to whether that type of conduct could be seen as enforcement or ensuring obedience of the law. Rather, the focus was on saying ordering someone to do something is akin to what the Secretary of State would be doing by ordering people to stay at home. That was the focus of submissions. And so my overall submission of to why the judge focused his answer as he did remains. But your ladyship, you obviously heard my broader submissions yesterday in terms of the two ways it can be put, but I don't repeat that.
We did. Well, thank you for that. I think you said actually you weren't sure as to whether or not it'd been mentioned below, but thank you for clarifying.
And just so that I don't intend to go to it, but just to give the references that they are there, the transcript is in the supplemental bundle tab 4, and as far as I could see, it's mentioned on pages 158 and internal page 76 of 158, page 160, internal page 79 of the transcript, and page 161, internal page 82.
Sorry, what was the last one?
Page 161 of the bundle, internal page 82.
Thank you. Thank you very much. So, Mr. Killen.
My lady, my lords. I will address the court on ground 3, which is IEH's challenge to the judge's conclusion that the clause requires the incident to occur within the radius rather than the effects of the incident. And we say that IEH's interpretation is clearly wrong. First, as a matter of the natural language of the clause. Second, as a matter of commercial common sense. And I propose to take each of those in turn before finally setting out Allianz's submissions on why IEH is wrong to seek to derive support from Sir Richard Aiken's arbitration award in Salon Gold. At the outset, we do say that, save in relation perhaps to ease of proof, it's not particularly clear to us what difference, in this case, this point in fact makes, because the theatres were all in cities and conurbations, and so it's not clear why this point is in fact being argued. But nevertheless, it is a matter of interpretation, and so we do, of course, go on to address it. Starting with the natural language of the clause, the court will, of course, be very familiar with the wording of the clause by now, but it may help to have it up on screen. That is in the supplemental bundle, tab 2, page 131. And it is really the first 2 lines of the body of the clause that we are dealing with. And Allianz's case, as was accepted by the judge, is that the natural reading of that clause is that the words likely to endanger life describe the incident, and the words within 1 mile of the premises identify where the incident likely to endanger life must take place. The first point we say against IEH's reading of this clause is that for it to make sense, one would expect a comma after the word incident. So it would read as a direct result of an incident, comma, likely to endanger life or property within 1 mile radius. We say that without that separation, likely to endanger life most naturally describes the preceding word, the incident. Now, in this clause, the draftsperson, we can see, does use commas. For instance, there's a comma after policing authority, but there isn't one where we say one would expect it if IEH's reading were correct. So we say that in this case, it should be inferred that the absence of the comma was intentional. It needs to be read as written. And the court was taken to a passage yesterday from the Salon Gold Arbitration Award where Sir Richard Aikens made a similar point. One shouldn't put commas in when they're not there. And there's a similar point as well made by Lord Justice Nugee in the Almana decision. We don't need to turn that up, but it's at paragraph 66. Now, punctuation aside, we say that a further point against IEH's proposed interpretation, and why Allianz submits it would not be a natural reading, is that on IEH's interpretation, the incident is left largely undescribed. The words likely to endanger human life is relegated to describing what must occur within a particular location, and the incident is left largely unqualified and unexplained. Now, it might, of course, be said that requiring there to be an endangerment to human life within a particular radius means it could be inferred that the incident is of a nature that would be likely to endanger life. But we say that is a less natural, and we say less clear and less obvious reading of the clause, one in which the nature of the incident is described rather than its effect in a place, is, we say, what one would expect if one were coming to this clause as the ordinary reader. Now, if it's accepted that those words, likely to endanger life, describe the type of incident with which the clause is concerned, then we say it follows that it is the incident as described which must take place within the identified radius. Now, in the skeleton, IEH seeks to compare this clause, S31, with the clause S29/1. Now, this wasn't a point that was pushed by Ms. Higgs orally, and we say she was right not to do so. As Ms. Higgs rightly accepted, this is a policy that is of a pick and mix nature, and that means that comparison between clauses is unlikely to give much of an answer. More fundamentally, though, we say, and as the judge also said, comparing one clause to another is of no real assistance if the wording is very different, because in that case, one tells you very little about what the other means, even if this were drafted as a coherent whole. And one can see S29 on the prior page, page 130 of the supplemental bundle. And we say that the differences between reading those two clauses are very apparent. S29 is directed at two specific types of event: damage to property nearby, which restricts access, and the presence, actual or suspected, of an explosive device, which results in closure. Second, the location with which those specific events must take place is not defined as a specific demarcated area, but by the concept of vicinity, which, as Mr. Justice Jacobs said in the London Excel case at first instance, is a flexible concept, a concept with a degree of elasticity. Contrast that, we say, with our clause, S30/1, that doesn't define the type of incident, save that it must be one that endangers life or property, and it has a radius with a strict boundary. So we say that these are two quite different clauses offering different cover, and comparison is therefore difficult, even if this were not a pick and mix policy. So we say that the natural meaning of the clause is one in which likely to endanger life describes the incident, and it is the incident so described that must take place within the specified radius. Now, Allianz's primary case is that the words used are sufficiently clear and so one does not get to questions of commerciality. Ms. Higgs suggested that we say that IEH's reading is not possible. I don't go that far. We don't say that it's not a possible reading, but we do say it's not the or even a natural reading. So my case at its highest is to say that there's not sufficient ambiguity to ask whether commercial factors make a difference. But happily for me, I don't need to succeed on my case at its highest, because we say that in fact, if one does look at commercial factors, they all point in favour of we say the natural reading of the clause is. So if one does use commerciality as a cross-check, we say that there are two commercial factors that point strongly towards Allianz's case and away from IEH's case. And the first is that, as the judge found, on IEH's interpretation, the radius provision in the clause would be largely redundant. So if an incident could happen anywhere, but its effect was to close the premises or prevent or hinder access to the premises as a result of a likely danger to life within the radius, then we say, why have a radius at all? It would have been enough in those circumstances simply to provide for the effects of an incident in consequence of which access to the premises would be prevented or hindered. So any prevention or hindrance as a result of something likely to endanger life would suffice. There's no need to prescribe that there is a 1 mile radius. We say that, on the contrary, Allianz's interpretation does give the radius real meaning, and so we say that points towards its interpretation being correct. Now, in an attempt to justify the radius, Ms. Higgs gave an example of the riots in Liverpool, resulting in a nationwide curfew affecting theatres in London, and it was said that in those circumstances there'd be no danger to life in London, and so the radius would bite. Now, to that we say two things. First, we say that example is rather strained. It's quite a convoluted and unlikely situation that had to be posited to try and justify the radius, and we say that that is an indicator that this isn't likely the intended reading. But second, we say that that example, even on that hypothetical, doesn't in fact prove the point that Ms. Higgs made. Because surely in that case a policyholder would argue that there must have been a risk of the riots spreading to London, otherwise why would the government impose a nationwide curfew? And that again, we say, would essentially, if the policyholder were right, render the radius meaningless. The second point of commerciality that we say points towards Allianz's interpretation and away from IEH's is to an extent exemplified by that example, which is that identifying where the incident takes place can be done in a certain and straightforward way, but identifying where the effects of the incident spread is rather more difficult. And that was a point that was accepted by the judge also, and that was at paragraph 490. Now, of course, one might say, as Ms. Higgs did in her submissions, that really what one is concerned with is the effects of the incident being the prevention or hindrance of access, so the closure in this case. But to the extent that's right, that rather reinforces my first point on commerciality, to say, well, why have a radius at all? But we say, going further than that, why the effects of the incident are harder to determine than where the incident itself takes place can be made good by an example. And building on the example we have in our skeleton, if one takes, for instance, a theatre in Southampton, and one uses COVID as the relevant situation, because of course if we're here at this point, then a case of COVID must have been found to be capable of being an incident, and the closure must have been found to be capable of being by government. So if one takes the theatre in Southampton, now you might say that a person with a disease in Newcastle is unlikely to endanger life in a theatre or within a mile theatre, a mile radius of a theatre on the south coast, that's some 300 odd miles away. But just as the point was made by my lady yesterday, people travel. So what about the person that catches the disease in China and then comes to England? If one has maybe a case of disease in Bournemouth, some 30 miles away from Southampton, we might say they might be more likely to travel. They might come to Southampton for their shopping. They might go to the theatre there. And so there would be an argument about which of those cases endangered life within the radius. What about the person 2, 3 or 4 miles away? One can see it's very hard to draw the line, and that means there's uncertainty. So the benefit of having a clear boundary prescribed by a 1 mile radius would, we say, on IEH's interpretation, be undermined. On the other hand, if one's looking at where the incident takes place, there's a clear test which can be applied. The incident must take place at a time, at a place, and in a certain way. You can identify where it is, and the uncertainties don't exist. Now, in the skeleton argument, a point taken by IEH, and again, not pressed in oral argument, is to rely upon comments from Sir Richard Akins in the Salon Gold Arbitration Award, where Sir Richard said he thought that the test of the effects was easy to apply. Now, we respectfully disagree. We say that the example just given of the person in Bournemouth and the theatre in Southampton exemplifies why it can be difficult, and would be difficult in this case, to apply the test. But even if one takes the examples given by Sir Richard, he uses an approaching storm or a radiation cloud, the first thing we say is question mark whether they are in fact an incident or whether they are an emergency. And of course, Sir Richard was dealing with emergency. But assuming that they were to satisfy our clause for the minute, we say that what if the closure was ordered of the theatre in Southampton for the approaching storm that was coming across the far north of the country? If the storm blows itself out well before it ever reaches Southampton, then one might say that actually there was never a danger to life within the radius. What if the storm was never expected to come down that far? One would have arguments about that. So we say that in fact those examples are not ones which show that it's easy to apply in this case. We say in fact they rather make the point. Likewise with the radiation cloud, that might depend on which way the wind is blowing. What if there is no wind? What if the wind were always planned to blow in a particular direction, but out of an abundance of caution, all regions were shut down? So we say that in fact, contrary...
Well, the test is likelihood, isn't it? So
it is.
You'd have to form a judgment about that at whatever is the relevant time.
Yes, and that would, of course, we say, lead to debate. Whereas if what one is doing is simply identifying where the incident takes place, then it's rather clearer and rather easier. Now, there was another point which was made by IEH, which is this question about unfairness or arbitrariness. And the example given in the skeleton is shops near Sizewell B power station, one just within the radius and one just out of the radius. And the point made was that on Allianz's interpretation, one would have cover and one would not. But we say that there's nothing, there might be something arbitrary about it, but that certainly doesn't point away from Allianz's interpretation, because the reason one has cover and the other doesn't is because that is the scope of the agreement that was struck between insurer and insured. Insurance, of course, is not unlimited. The cover that's provided reflects the cost that's charged, but also, of course, the parties, both parties, want a level of certainty. The insured wants to know what they are covered for. The insurer wants to know what cover they are offering. And so we say the fact that on slightly different factual scenarios, one place might have cover where another does not, is not something that points away from Allianz's reading. And in fact, we say, when it's properly assessed and analysed, it points towards Allianz's reading. And Ms. Higgs referred to the point in the Supreme Court. In the course of discussing the weighing approach, this precise issue was recognised by the Supreme Court, and that's in FCA and Arch, Volume 2 of the Authorities Bundle, tab 9, and at page 465, paragraph 204.
Did you say 204? Paragraph 204.
Paragraph 204, yes. And here the Supreme Court are discussing the weighing approach. And the example is given here of the difference of a speed limit of 30 miles per hour means at 29 miles per hour, one is not breaking the speed limit. At 31 miles per hour, one is. And then just by letter C in the paragraph, the Lordships go on to say, in a similar way, it is entirely reasonable for insurers to set a territorial limit to the scope of business interruption cover, which is arbitrary in the sense that there is no particular logic for selecting a radius of 25 miles rather than 24 or 26. To define it, and though the consequence of selecting a specific distance will inevitably be that there will be no cover for business interruption, in some cases, where on very slightly different facts, there would have been cover.
And the case also illustrates that other radii are available.
Exactly. Yes, my lord. And we say, of course, it applies equally to different radii, but if the insured had wanted a larger radius, then they could have negotiated for it, they could have requested it. So we say that once commercial considerations are brought into account, Allianz's interpretation is further supported, because Allianz's interpretation gives the radius meaning, and it also provides the parties with a policy, with the parties to a requirement that is easy to apply and gives clear answers, so both parties to the policy know where they stand and what the cover is that they have purchased. Now, that then brings me on to the third and final part of my submissions, which is Salon Gold. And on this, we say that IEH's attempts to derive support from Salon Gold are misplaced. First, we say, because the clause which Sir Richard was dealing with is materially different, and the reasoning, therefore, cannot happily be transposed across to this clause. So if it were authority, and obviously it's not, we would say, to use that language, that it should be distinguished. The second point, and I don't need to go this far because obviously it's not binding, and it is, we say, distinguishable, but in any event, we say that insofar as there might be considered to be a conflict between Sir Richard's analysis and the judge's analysis below, it's the judge's that ought to be preferred. Now, the wording in Salon Gold, just to remind ourselves of it, is in the Authorities Bundle, tab 14, which is in volume 3, and one can see it at page 752 in paragraph 5. And the relevant parts of the wording provide cover for loss as insured under this section, resulting from the actions or advice of a government or local authority due to an emergency likely to endanger life or property in the vicinity of the premises. Now, we say that there are 2 points of distinction with the present clause. First, we say this refers to emergency and not incident. And second, we say this refers to vicinity and not a defined radius. The primary point of distinction is the first one, of emergency. And as Ms. Higgs accepted, the arbitration award proceeded on the basis that the emergency was the whole COVID-19 pandemic. So if it's the whole COVID-19 pandemic, it's not geographically located, or at least not specifically. It is across the entire country. And so we say it's not difficult to see why a clause referring to emergency would therefore be interpreted differently. One would be less likely to expect something that is not, or not necessarily, geographically located to have to take place within a radius when one is reading those words. But we say the opposite is true if you have a definition like incident, which does have to be geographically located. So that's why we say that even if it might be said that these clauses are syntactically similar, their likely meaning is very different. And so one can't transpose across Sir Richard's conclusions to this clause. And we note also that, in fact, in Salon Gold, there were 3 arguments made. The third argument made by the claimants was on the assumption that the emergency was a single case of COVID. And that argument proceeded on the basis that the single case of COVID must have been within the radius, or within the vicinity in that case. And we say that rather proves the point, that once one is talking about an incident, when one's talking about a single case of COVID, then naturally one assumes it must be within the radius. And the argument there wasn't pursued at all in relation to a single case being outside the radius. We can see that argument summarised at paragraph 72, which is on page 776 in the same tab. It's the summary of the argument under the heading G, the claimant's third argument.
Sorry, which paragraph?
Paragraph 72, my lady.
Oh, paragraph 72.
I apologise. On page
No,
776.
it's my fault. I've got 772 as the page rather than paragraph 72. Thank you.
Now that is the primary distinction between Salon Gold and this case, but we also say that vicinity is a second distinction, because we say that whilst it can operate similarly to a radius, it is a flexible concept. And I've mentioned already that Mr. Justice Jacobs in London Excel at first instance describes it as such, and so does Sir Richard in the Salon Gold Award at paragraph 68. In the last line, just on the previous page, 2 pages prior, 775, he concludes, to that extent, in the vicinity of the premises is a description that must be applied flexibly in individual cases. Now, this isn't as significant a distinction as the emergency distinction, but we also say that it's not perhaps as difficult to see that where the radius is not hard-edged, it's not a specific boundary of 1 mile from the premises, the arguments such that we make here concerning the ease of proof and the certainty and scope of cover have a little less force. Conversely, we say they have more force in our situation where we do have a hard-edged boundary. And so if further points of distinction were required, we say that vicinity provides another. Finally, we say that to the extent that the court does consider that there is an analogy between the Salon Gold wording and our wording here, and that so essentially emergency can be equated with incident and the hard-edged radius can be equated with vicinity, then we say that where Sir Richard and the judge take different approaches, it is the judge's approach which is to be preferred. And we say that because insurers in the Salon Gold arbitration did not appear to make any argument before Sir Richard to the extent that the effect of the emergency having to be within the vicinity essentially denuded the point, the requirement of a radius at all, of any meaning. And we say that because that point wasn't run before Sir Richard, he didn't have it in mind, whereas the judge, of course, did firmly have that point in mind, and it supported the conclusion that he reached. We say that had Sir Richard been presented with that argument, he too may well have reached a different conclusion. So if one can equate the two, we say that one is to prefer the judge's reasoning. So for these reasons, we say that the natural reading of the clause is that it must be the incident which occurs within 1 mile of the premises. To the extent that they play a part, we say that commercial considerations lend weight to Allianz's interpretation and undermine that of IEH, because Allianz's interpretation gives effect to the radius and is easy and straightforward to apply and means that the parties know the certainty of the cover that they've been given. We say that Salon Gold does nothing to disturb those conclusions. Unless I may assist further, those are my submissions on ground 3.
Thank you very much. Thank you, Mr. Killen. Ms. Higgs.
My lady, my lord, just to pick up one question which you asked me yesterday about the Salon Gold arbitration,
Yes.
which was whether it had been appealed. I'm told by Mr. Gruder, who appeared in it, that the parties had agreed beforehand that it would neither be appealable and not confidential, so that it was agreed there would be no appeal
Right.
from it.
Thank you very much.
My lady, my lords, I'm going to take my reply submissions in the order of incident, policing authority. I don't think I'm going to reply to anything that Mr. Killen
Of course.
has
Thank you.
just addressed, but I'll be corrected by those behind me if I need to. The first point, just in relation to then ground one and incident, Mr. Doherty started by just picking up some points on the principles of contractual construction. I don't need to tell the court about those, and they are, as Mr. Doherty says, common ground. There is just one point that I want to just emphasise. He made the point that one needs to consider the question of the proper contractual construction at the time of contracting, not by reference to hindsight. And the time of contracting was pre-pandemic, and we accept that. But that doesn't mean that you construe the court laws by asking what sort of events would an insured or an insurer have expected this clause to cover, and then say this incident doesn't fall for coverage because it isn't the sort of incident we were expecting. I do say that because at times Mr. Doherty, with respect, did start making submissions that went down that route. He said that by contrast with the clauses that the Supreme Court was looking at, here we were looking at a clause which is looking at a policing authority reacting to an incident by closing roads. And I just do then sound a note of caution that one starts the exercise of construction by looking at the words used, the iterative process that's been set out in many Supreme Court cases. I also just make the opening point that insurance very often responds to the unexpected. Indeed, some might say that's the point of insurance. Mr. Doherty made some submissions on whether the word incident is or is not synonymous with the words occurrence and event, and you have my submissions on that and I won't repeat them. He did accept that the words occurrence, incident and event can be used synonymously. He said in this clause, incident was not being used synonymously with event or occurrence. It had a different meaning. And he sought to persuade the court that the clause itself is, using his words, quite clearly distinguishing between the words incident in the first line, or wherever it is, and the word occurrence, because the latter, where it appears, is referring to the composite peril, not just the incident, but also its consequences, the prevention of access. Now, I say the fact that the words incident and occurrence are being used synonymously in the clause is illustrated both by the fact that in the proviso, the word occurrence could have been replaced with the word incident without changing the meaning of the clause at all. And secondly, the fact that in the previous clause, the draftsman in fact used the word incident rather than occurrence in the proviso. So I do say they are used synonymously in this clause. But even if Mr. Doherty's analysis is right, and the draftsperson was deliberately using different words, with occurrence to denote the composite peril, that doesn't indicate that incident is being used in any narrower or more specific sense earlier in the clause. So I'm not going to say anything more about the synonymity of the words. You have my submissions. Mr. Doherty's key point about the difference between an incident and an event or an occurrence is that in order to constitute an incident, there has to be an additional element that the happening has to be detectable or observable. And he put it slightly differently at different times, but the essence of it, I think, was detectable or observable. My first point, which I made yesterday in opening, was that you can have something happening which can properly be described as an incident without there being any contemporaneous awareness that that thing is happening. And I've made those submissions. My next point is that COVID, in cases of COVID, were not undetectable. COVID is something which could be detected. So if the additional requirement of an incident above and beyond an event or an occurrence is that an incident has to be detectable, then a case of COVID satisfies that requirement. And my third point is one I've already made, but I just want to give the court a reference for it, which is that it was known that there were cases of COVID throughout the country in March 2020, at the point at which the regulations were passed, even though the government did not know precisely how many cases there were or precisely where those cases were. And if I could ask you, please, to turn to the Court of Appeal's recent judgment in the At the Premises test case, or the London International Exhibition Centre, which is at volume 2, tab 12, page 669. And in paragraph 70, the court, including my Lord Justice Males, there recorded what the Supreme Court had said in paragraph 212 of their judgment, which is, the basis for this conclusion is the analysis of the court below, which in our opinion is correct, that each of the individual cases of illness resulting from COVID, which had occurred by the date of any government action, was a separate and equally effective, I think, cause because of that action and of the response of the public to it. And the court in this case went on to say in paragraph 71, that is a finding of fact which must apply equally in the present cases, and one which in our view is self-evident from the agreed facts about the matters which Sage and the government were taking into account in their decision-making at the relevant time. It cannot be wished away by saying that the Supreme Court meant to refer only to reported cases and not to all cases which had occurred by the relevant time. It means that the government action was taken not merely in response to the still relatively low number of reported cases, but in response to each and every case of COVID-19 which had so far occurred, whether or not it had been reported. These unknown cases, referred to the hearing before us as the known unknowns, were known to exist, even though the government did not know precisely how many cases there were, or where precisely they were. There is one final point I'd like to pick up in relation to incident and what Mr. Doherty said about the requirement that an incident has to be observable or detectable. He said at page 131 of the transcript that the ordinary person wouldn't describe contraction of a disease as an incident, even though it might be a relevant incident for a public health official. Now, to that we say quite. The fact that an ordinary person might not describe something as an incident does not give you the answer to whether it is an incident within the meaning of the clause. I'd just like also to make clear what the divisional court did and did not decide about an incident, because Mr. Doherty said that the divisional court accepted that the word incident does have an additional element, the element of being detectable and observable. And he also suggested that the divisional court had said that the word incident connoted something that is manifest and observable. I just want to remind you exactly what they did and didn't say. If we could possibly take, please, the Authorities Bundle, tab 1. Sorry, volume 1, tab 8. And go to page 338. What they said in paragraph 404 is the entire case on this clause founded on the requirement for an incident. We agree with Mr. Gazeman that this word should be given the same essential meaning as an event, something which happens at a particular time, at a particular place, in a particular way. So that's what they said, the meaning that should be given to the word. Now, I accept, and we've looked carefully at what they said in the final two sentences of paragraph 405. And they said there what they said. But I just want to be clear, there is no part of their judgment where they say that an incident means something different from an event or an occurrence, or that it has to be observable or manifest. As I submitted yesterday, they didn't explain the point beyond those two lines. The next point that I just want to be clear about is what preliminary issue the judge was asked to address and our case. Because the preliminary issue, and this is set out in the judgment, is does a case or cases of COVID amount to an incident likely to endanger human life? And Mr. Doherty said yesterday that for the purpose of this preliminary issue, it was simply put in a binary sense. The question which was being addressed was it enough merely to have it and walk around with it, irrespective of any knowledge? And that was the claimant's case. I just want to show the court what our pleaded case is, so that the court is aware of what our case is. If we could go, please, to the amended particulars of claim, which are in volume 1. Sorry, the core bundle, apologise. At tab 15. And page 297. If we start at paragraph 34. The case is that the 21st of March regulations and the 26th of March regulations lay before Parliament as a direct result of an incident likely to endanger human life within a 1 mile radius, namely the incidence or occurrence, which is a synonym of incident, of at least one case of COVID within 1 mile of each of the claimant's premises, and then alternatively a case or case outside, and that's the point that we've been arguing about. And if we could then look down to subparagraph 2, at all material times from at least March 2020, there were actual or threatened cases of COVID-19 which were likely to endanger life at each of the claimant's premises. Now, just pausing there, the threatened case is not pursued. It is only actual cases. And turning over the page at subparagraph 4, each separate case of COVID-19 was a separate incident and was likely to endanger human life, etc. So our pleaded case is a case of COVID as an incident. Now, we did argue at first instance, as I have done before this court, that someone having COVID itself constitutes an incident in the same way that it constitutes an occurrence. That is our case. And that contemporaneous knowledge that that person has COVID, either by the person themselves or by someone else, is not necessary. That is exactly what the Supreme Court has found in relation to the word occurrence, that a case of COVID falls within the ordinary meaning of that word, and that the case does not have to be symptomatic, diagnosed, or reported. And so we say, for all the reasons that I gave in opening and have given so far, that the answer to the preliminary issue that the judge was asked should be yes. However, if this court were to accept Mr. Doherty's submission that an incident requires something more, that there is only an incident if the effects of COVID are observable, which is how he put it yesterday, then we submit that the answer to the preliminary issue should reflect that. The answer to the preliminary issue would then be a case of COVID without more does not constitute an incident, but a symptomatic or a diagnosed or a reported case of COVID does constitute an incident. Now, that's not my primary case, and for all the reasons I've given, I say that's not the right answer. But if the court concluded that is the right answer, then we say that is the answer that they should give. And in that regard, my Lady Justice Macur put to Mr. Doherty yesterday that if someone with COVID collapsed in the street and an ambulance was called, was that capable of being an incident? And the answer was yes. So Mr. Doherty does accept that this clause covers disease. He says it would only be an unusual case where it does because there has to be something observable or manifest. I also just do want to make this point to sound a note of caution.
But you haven't pleaded that there was any diagnosed case in the radius.
My Lord, we've pleaded that there were cases. These were preliminary issues to determine certain preliminary issues. All the other cases that were heard by Mr. Justice Jacobs are proceeding and will now go to proof. How will we prove our cases of COVID? What sort of cases of COVID? But my Lord, this was never, our claim was dismissed because of the judge's decision on policing authority, which I will come on to. But this point in itself is not a knockout blow for our claim.
If you desist, I accept that. If we had failed on policing authority and only succeeded on incident, I do accept that. There would have then been the question as to whether they could prove what an incident was. And it's worth looking that the judge, of course, did make clear that he was saying a case in of itself. He wasn't seeking to answer whether there might be something more that's necessary. So that I would accept is correct. That simplifies matters.
The only final point I want to make is in relation to causation. Because as this court knows, Mr. Doherty did have a causation appeal. That was ground one of his cross appeal. And that cross appeal, that ground one, is no longer pursued. So there is no causation argument being pursued in this case. And it's very much open to him, of course, to make all the arguments that he can make about what incident means. But I do want to just stress that there are questions of construction about the meaning of the word incident, and they can't be allowed to stray into the causation question of whether that incident caused the restrictions. He accepts where we are on that. That is all I wanted to say on the first ground. The second point I now want to address is any policing authority. The question is whether access to the premises was prevented or hindered by any policing authority. And the judge said that access was not prevented or hindered by any policing authority because central government does not constitute a policing authority within the meaning of the clause. And as we looked at yesterday, his answer was that a policing authority refers to the police or other bodies whose function it is to see that the law is obeyed and enforced. And as I understood Mr. Doherty's submissions yesterday, he does say, as his narrower or stricter ground, that the judge was right to hold that the policing authority extended only to the police and other bodies whose function it is to see that the law is obeyed or enforced. And he described that as his strict or narrower view. He also advances a broader approach that it encompasses bodies which do a different sort of policing, but he still said that wouldn't extend to central government and the action which was taken in this case. Now, just looking to start with at the judge's narrower construction, we say that cannot be right, because if it is right, the scope of this cover is wholly illusory. Gas leaks, fires, traffic accidents, etc. have been repeatedly given as the paradigm examples of the sort of incidents likely to endanger life, which everyone would expect to be covered by this clause. Other than the police itself, the authorities who are required to, and who would be most likely to, respond to such incidents are the fire and rescue authorities. It is not the function of the fire and rescue authorities to see that the law is obeyed and enforced. I showed you the core functions yesterday. That was sections 6, 7 and 8 of the Fire and Rescue Services Act. When they close off premises or roads or areas in consequences of incidents likely to endanger life, they are protecting life or property. And similarly, that is what the police are doing, or will usually be doing, when they prevent access to premises or areas in consequence of an incident likely to endanger life. They are protecting life or property. And Mr. Doherty said yesterday that they would say that a core element of policing is protecting public safety. And we agree. And as I said yesterday, in the context of this clause, that is the relevant policing that is being referred to. It is not about policing in the sense of ensuring that laws are obeyed and enforced. And I just want to give you a sort of concrete example on that. Under certain statutes, there is an offence of persistently selling alcohol to children. And there are powers that the police have to close licensed premises if there is good evidence that a premises licence holder has committed the offence. But there are also numerous police powers and other authorities' powers to close licensed premises where there is no offence being committed or suspected, and where the powers are designed to protect the public and enforce public safety, irrespective of any fault. And we say ordinarily when the police or any other authority is responding to an incident, it would be not enforcing compliance with existing laws, but acting to promote public safety and protect human life and property. And we say this court plainly does respond when the police and other authorities are preventing access to premises not as part of ensuring the law is obeyed and enforced, but because they are preventing or hindering access to protect human life. Because the premise of the clause is that there has been an incident likely to endanger life near the premises, not that there has been a failure to comply with a law that needs to be enforced. And my lords, I do say that if the cover were really limited to instances where the police were preventing access as part of ensuring that people obeyed the law, then it really would be illusory. My Lord Justice Mail said yesterday that if the police had to take action to shut down my client's theatres because they didn't comply with the lockdown regulations, they would have committed an offence and they wouldn't have cover. And Mr. Doherty went further. He said, if that is the factual scenario that has transpired, there would have been no fortuity and therefore no cover. And there are a raft of other points that insurers would make. You'd fail to comply with regulations and it's your obligation under the policy to do so. So whenever premises are being closed because of a failure to comply with a law, insurers will have an answer: there's no cover. That's not what this clause is doing. So just coming back to the fire and rescue authorities, we say they must be included within a policing authority because they are the prime candidates who respond to incidents of this nature, which insurers say are the paradigm examples falling in with the clause, and which we accept fall within the scope of the clause. And we say the same is true of the highway authorities and the other traffic authorities and local authorities, which have powers to prevent access to premises, streets or areas to protect public safety. So we do say the judge's answer that a policing authority refers to the police or other bodies whose function it is to ensure that the law is obeyed and enforced cannot, with respect, be correct. Now, then turning to the broader approach, which Mr. Doherty, I think, advanced in the alternative, he says, well, even if the judge is not right, and policing authority must be understood more broadly, and there's a bit more flexibility about what it means, what happened when access was prevented by the regulations passed on the 21st of March does not constitute access being prevented by a policing authority. And his core point, as I understood it, was that there is a distinction between making regulations and normal policing or normal acting as a fire brigade using existing common law or statutory powers. And we say that distinction simply doesn't stand up to scrutiny. There are numerous statutes which give the police, the fire and rescue authorities, the local authorities, organs of central government, powers to respond to different situations in different ways. When Matt Hancock passed the 21st of March and 26th of March regulations, which had immediate effect, he was exercising an existing statutory power under Section 45C of the Public Health Act. And if I could just ask you, I handed up, rather unhelpfully, not in the authorities bundle, but the Public Health Act. And I wonder if we could look, please, if the court still has it to hand. At Section 45C. Sorry, the Public Health Control of Disease Act 1984. And just to be clear to the court, I printed off for you Part 2A. This statute gives powers to central government and also to local authorities to respond to public health, in particular the spread of infectious disease or contamination. So this is the part dealing with the powers pursuant to which Mr. Hancock made the relevant regulations, but there are lots of other parts dealing with what powers local authorities have, for example. And if we just start at Section 45A, it says infection or contamination. The following provisions have effect for the interpretation of this part. Contamination includes radiation. Any reference to infection or contamination is a reference to infection or contamination which presents or could present significant harm to human health. And any reference to the spread of contamination includes a reference to the spread of any source of contamination. And if one looks down at 45C, this is the power that Matt Hancock exercised, the appropriate minister may, by regulations, make provision for the purpose of preventing, protecting against, controlling or providing a public health response to the incidence or spread of infection or contamination. And then if we could turn over the page, please, to Section 2, subsection 2. The power in subsection 2 may be exercised in relation to infection or contamination generally, or in relation to particular forms of infection or contamination, and so as to make provision of a general nature, to make contingent provision, or to make specific provision in response to a particular set of circumstances. And then, as I pointed out yesterday, 3C says that the regulations may include provision imposing or enabling the imposition of restrictions or requirements on or in relation to persons, things, or premises in the event of or in response to a threat to public health. And then paragraph 4 gives a bit more specificity as to what the restrictions can and can't do, or what they can do rather. And then 45D sets out restrictions on the powers to make regulations, so it's a circumscribed power. If we could then look, please, at the regulations that were in fact made, which I also handed up yesterday.
Should we look at 45F?
Sorry, 45F. Apologise.
Subsection 2 talks about health protection regulations conferring functions and providing for the execution and enforcement. Is that something we should consider?
Well, my lady, the submission I made yesterday, and I make again, is that Matt Hancock had at his disposal the police as part of the enforcement mechanism for the regulations he made. He was able to make it an offence, and he did make it offence to breach his regulations.
Well, making something an offence isn't the same as enforcement necessarily. So it's just we weren't taken specifically to the statutory provisions yesterday, and I just wonder if they are important or not to look at this 45F.
Yeah, my lady, yes. I say the fact that, and sorry, just that the relevant provisions that are referred to in the statutory instrument he made were 45C, which I have just shown you.
Yeah.
45F2, which is the one my lady's picked up, and 45P.
E.
Not
45E.
P.
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 I'm sorry.
Not sure. Oh yes, it 45P just says a power to make regulations under this part is exercisable by statutory instrument, And a power to make regulations under this part includes power to make different provision for different cases or different areas.
Which you did mention yesterday
Yes.
because of the...
Because of the local one subsequently. But yes, I say the fact that he had the power to make it an offence and to deploy the police and other people as his, as it were, enforcement team merely reinforces the fact that he was acting as a policing authority. And I've already made the submission, it can't sensibly be said that it's only the police when they're coming along and closing down my theatres who are the policing authority, because that simply takes away my cover. And then just on the regulations themselves, which are the Health Protection Coronavirus Business Closure England regulations, he makes reference to the fact that he is making the regulations in exercise of the powers conferred by the sections we've just been looking at.
Yeah.
They're made in response to the serious and imminent threat to public health posed by the incidence and spread of COVID, and et cetera, et cetera. And then what they do, as I showed the court yesterday in sections 2, subsection 2 and 4, is require people to close their premises. Now, we say that is no different in kind from what other authorities do when they are making orders preventing access to premises. They're exercising existing statutory or common law powers to respond to threats to public health or safety. Mr. Doherty yesterday accused me of being unreal to equate the police putting up a cordon with the Secretary of State passing regulations. But there is a huge range of different responses that different authorities have under different statutes, depending on the circumstances and the severity of the situation they're dealing with. The regulations which Mr. Hancock made may have been different in scale from something the police was doing. It's not different in kind. I have addressed you at length already on why we say a case of disease does fall within the meaning of an incident. And as I've said earlier this morning, Mr. Doherty accepted that infectious disease can fall within the scope of the clause. He accepted if someone collapsed with Ebola or COVID, that would be an incident. And we do say that is also an important point, because if infectious diseases are covered by the clause, then the response may well be at a broader or a national level. And here we pray and aid what was said by the court in the London International Exhibition Centre when deciding that a public authority included the government. And if I could just ask you to turn to Volume 1, Tab 1, 599. Oh, sorry, that can't be right. Tab in, no, not Volume 1, I'm so sorry. Is it Volume 2? Yep, sorry, it's Volume 2, Tab 11, 599. And this is Mr. Justice Jacobs' decision in the London International Exhibition Centre. A paragraph, starting at paragraph 326. Mr. Christie's submissions fairly acknowledge that it cannot be disputed that both central and local government have powers to impose restrictions on premises in response to manifestations of notifiable disease at the premises. The statutory context described in A3 above indicates the broad range of powers which were available to the national government, and then there's a reference to paragraph 78 to 88 of Lord Mance's award, which I took you to in part yesterday. And then paragraph 327, given the nature of notifiable diseases as described in the FCA test case and discussed in section D, the broad range of possible responses that might be required at either a local or a national level, depending upon the severity of the problem, there is, in my view, every reason to give a public authority the the broad meaning that it would ordinarily have. We make...
Which clause is he addressing there?
Now I'm going to have to ask for help here from those who are more familiar with this judgment than me.
Well, if you look at 322, as the basis of settlement provision for property damage refers to public authorities' requirements.
I think it's the insuring clause itself, my lady.
I asked the question because he's talking about the meaning of public authority in a particular clause, which
is indeed.
May colour the meaning of the phrase.
He is, and he's talking about it, I fairly accept, in a notifiable disease clause.
Yes.
Absolutely, and Mr. Doherty made the point yesterday that the clauses that the Supreme Court considering, some of them were notifiable disease clauses, and so self-evidently, when looking at the range of responses, they're responses to notifiable diseases. I take that point. The point I'm making is that on my submission, incident plainly covers infectious diseases. Mr. Doherty accepts that it does in some instances, and I am therefore saying that I do get support from the proposition that local, national, all sorts of authorities have power to respond to infectious diseases.
Ms. Higgs, did this point go to the Court of Appeal? I'm guessing not.
Well, my Lord Justice Males may know better than me on that point. I don't think it did. The public authority was submission refused.
It's quite a long judgment, so I'm not sure
I'm sorry.
recall all of it.
Anyone know? Public authority? I think public authority, I will be corrected, but I think it didn't go to the Court of Appeal. I think either permission was sought and refused or not given. But perhaps those behind me can tell us on that. If we could come back to that point. Sorry. Oh, okay. Sorry, thank you very much. I'm reminded that one of the clauses here was on the order of the medical officer of the public authority. That point, whether Chris Whitty did constitute the chief medical
officer of health.
Of the public authority, yeah, exactly.
Certainly went to the Court.
That went to the Court of Appeal. And what I can do, if we have perhaps a short break soon, I can identify the passages in the Court of Appeal's judgment where the point was dealt with.
I may be wrong, but I think I recall, whether in that case or others, refusing permission to appeal on whether public authority extended to the government.
Yeah, so in the Gatwick case, which was heard alongside this case by Mr. Justice Jacobs, the question there was, are the police or other statutory authority, does that include the government? And Mr. Justice Jacob held that statutory authority did include government and that Matt Hancock constituted a statutory authority. Permission was sought from the judge on that point and refused. Permission was then sought by insurers from the Court of Appeal on that point, and that was refused. So that point, other statutory authority.
Right, I think that's what I was recalling.
Can we please revert to you on public authority? And I think the answer is it was just in the context of the medical officer for public health. Yes. Okay.
But the clause that we're considering doesn't include public authority. No. It's policing authority.
My lady, yes. It's different language. My point is simply that an incident, I say, encompasses, among other things, disease. And I do pray and aid there the point that diseases, infectious diseases, Ebola, spread quickly, and that responses might be required at a national level as well as a local level.
Yes, but that then is a circular argument, isn't it, about the incident? Because if the incident has got to be somebody collapsing in the street or whatever,
well,
it's all
my lady,
contextual, isn't it?
I fully accept the clause has to be construed together.
Yeah. Okay.
I mean, Mr. Doherty made the point, it's a two-way street, I accept that.
Okay.
I mean, you say it means that you don't have cover for national responses, but maybe that's just the deal that you did. Policing authority means whatever it means, and you either come within it or you don't. And if you haven't got cover, well, you haven't got cover.
My lord, yes. And Lord Mance has held where the wording says other competent local authority, you don't have cover because this wasn't the action of a competent local authority. And my submission to you is the result is not the same with policing authority. And I want to make one, I'm conscious of the time, I've got about, I would say, 5 more minutes on policing authority. So if
well, let's get on.
Yeah. The language of the clause is access to the premises is prevented or hindered by any policing authority. Now, there are many formulations within this policy and elsewhere that are very much more specific about the sort of prevention and the sort of action. I'm not going to take you to all of them, but...
is this in response to submissions that we heard, or is it just an extension of the submissions that you made?
Well, my lady, it is in response, because Mr. Doherty said yesterday that there's a distinction between actions of the police, and I'll find the reference to prove it is properly responsive, but actions of the police in cordon and regulations, and they're different in kind, and this clause covers actions of the police of the sort of putting up a cordon. And the point I am just making is there are lots of clauses that say action or order of the police or other competent local authority. There is indeed wording elsewhere in this policy. There are lots of clauses that were considered like that in China Taiping, actions or advice of the police or other competent local authority, instructions issued by the police or other competent local authority, etc. Here we have none of that, by any policing authority. There is no specificity as to how they have to prevent access. It is purely the question that the access has to be prevented by a policing authority. And I do say again, that is deliberately flexible because there are a range of responses that may be elicited by different situations of different severity. There are 2 final points I want to make. One is that Mr. Doherty referred to the OED definition of policing, and the judge set that out at paragraph 505 of his judgment. With respect, we say that you get no help and the judge got no help from that definition. And indeed, if one were to import the definition of policing into policing authority, then what you would have is the authority with responsibility for providing a police force. And on any view, that isn't what this clause means. The next point, and I think it's the final point that I want to make, is about first impressions. My Lord Justice Mayles had said in a recent case in the Court of Appeal that first impressions can be important in construing clauses. They can. Mr. Justice Jacob said in his first instance that his first impression was that it was a very considerable stretch to read any policing authority as including the government. But we say this is a case where even if your first impression was that any policing authority doesn't include organs of central government, this is one of those cases where proper analysis takes you to a very different conclusion. Because if you look at the authorities which will in fact be responding in order to prevent access to premises, any policing authority cannot be limited to bodies similar to the police, whose job it is to see that the function of the law is obeyed and enforced. And I do repeat the point that I made at the outset of my submissions, which is that any policing authority is a broad, flexible term. Now, Mr. Doherty said yesterday that it has a straightforward meaning, those with authority to carry out policing, and policing authority means an authority which polices. With respect, we did not find Mr. Doherty's explanation of what it did and didn't cover straightforward. And we say it is, as I said, a broad, flexible term. And it is simply that access is prevented by any policing authority. And the final, and this is the final point I want to make, is just as the course that this court should take. Following the trial of preliminary issues, My client's claims were dismissed because of the answers on the two preliminary issues, and this was the critical point, as we've just discussed. And as I've already said, the other claims which the judge had at the same time are proceeding to the next stage. Now, we say that the judge's answers on both of these threshold issues were wrong. The court should say so, and it should answer those preliminary issues. As we've said in our skeleton argument, we've set out what we say the correct answers are. But I also do say that if this court considers the judge was wrong to answer issue 28.4 as he did, but it's not yet persuaded as to the proper meaning of policing authority, and specifically it's not persuaded that access was prevented by any policing authority on the 21st of March, and it considers that the issue should be considered further by the judge, then this is an issue which should be remitted to the judge with that direction.
Sorry, I haven't followed that. What is the point which we would invite the judge to consider further on this hypothesis?
Whether by the regulations on the 21st of March 2020, access to the premises was prevented or hindered by any policing authority. My Lady, my Lords, that's all I was intending to say by way of reply, and it seems that now might be a convenient moment.
Thank you very much, Ms Higgs. Thank you. So, 5 minutes. Thank you.
All right.
You said in a letter to
Yeah,
the court,
letter was
I don't think we've.
I just have to say.
Might be a bit over. Yes, quite. I don't think I'll be very long, but I
Yeah,
didn't think
I mean,
I'd be
it's
quite as
pretty-
long as I. Could you just look, because I'm not familiar with that case. What the court just look at the clause that they were considering. And then they'd actually say, and then what they said. Where it went to the court of appeal. Richard, did that sufficiently cover?
Yeah, that was good. Yeah. I think it's 284.
Is that the why not? Is that correct?
Well, that's the issue. The premises closure and restricted extension. James, what you want the actual clause itself?
Just the clause. No, so we'll get the references for them.
It's the reference.
Yes, sorry.
All right.
My Lady, my Lords, just before Mr. Doctor starts with his appeal, just to give you the reference and clarify, or rather correct what I said earlier, in the London International Exhibition Centre, the relevant phrase clause required the closure or restrictions to be placed on the premises on the advice or with the approval of the medical officer of health for the public authority. And it was in that context that Mr. Justice Jacobs was considering the meaning of public authority. And that point was appealed to the Court of Appeal. And the Court of Appeal upheld Mr. Justice Jacobs' decision that Chris Whitty did constitute the medical officer of health for the public authority. And the relevant passage in the Court of Appeal's judgment is at volume 2 of the authorities bundles, tab 12, paragraphs 74, which is at page 670, all the way through, I'm afraid, to paragraph 94 at page 678.
Yes, the real problem there was that medical officer of health was a person who had existed up until about 1972 as part of local government and had then been abolished, but who continued to live on in insurance policies.
Oh, yes.
Right, so Mr. Doherty, we're at the cross appeal now.
My Lady, that obviously brings us to the cross appeal. I'm conscious of the question I think we were both asked yesterday in terms of what would the impact be, or in terms of having to make a decision on the cross appeal were you to find for insurers in relation to the main appeal on one of the threshold issues. I think the difficulty is that my learned friend is not in a position, and I don't criticise her for saying that they wouldn't seek to appeal that decision, and accordingly, given that it theoretically could go further, we can't say therefore that we wouldn't invite this court to answer the cross appeal, otherwise we would effectively have lost that opportunity. I do recognise, of course, depending on what the court decides in relation to the first question, it may be possible to deal with the cross appeal more briefly than would otherwise be the case. But I'm afraid, like my lady, I don't have better news for the court than that in terms of being able to sort of narrow the issues.
Well, I wouldn't regard it as better or worse news, but we just needed to know. What about some housekeeping? The cross appeal, and this is no pressure whatsoever. Can you give us an idea of how long you'll be, Mr. Doherty? And
I would say just after lunch. I think originally we had hoped that we'd finish by lunch.
Yes.
But I would say that I would finish just after lunch. I think my learned friend was hoping to be relatively quick in response, but also I'll let her answer that question.
Yeah, my lady, I wouldn't have thought more than half an hour.
Right,
It might be
okay.
quicker.
All right. Thank you very much indeed. That's very helpful.
My Lady Lords, the cross appeal relates to two grounds. The causation ground, as my learned friend has pointed out, is not one that's being pursued. It is being pursued in the Gatwick cases, and where it's the real issue in January. Obviously here, it would not have been a key issue, and therefore Allianz take the position that it's not going to pursue it here. So we are simply referring to essentially the limits question. First, what's the true construction of the limit of indemnity per claim, and secondly, should the wording be corrected by interpretation to remove what would be, we say, a clear mistake, and to answer the aggregation clause properly. I'll come to that. The more substantial ground in terms of time is the first one. They're both equally important. The third ground is one that I will be able to deal with really very briefly, because the point is really a very short one. In relation to ground 2, the judge concluded that the limits of indemnity per claim operated on a per premises basis, and he set out his conclusion on that. We don't need to turn it up, but it's in Core Bundle 11, page 229, between paragraphs 537 and 550. Our case is the judge was wrong to say that the limit of indemnity per claim operated on a per premises basis, as opposed to by reference to the insured business as a whole. And that matters, this distinction, because while some of the insured companies in these group of theatres only had one theatre, others had multiple venues. And I should also say at the outset that we accept that normally prevention of access to different premises will in practice give rise to different claims. But that is not because a claim is defined in this clause by reference to each set of premises, but rather because any claim resulting from the interruption to business, we'll come to that, will have been different, as it will have been the immediate result of a different prevention of access by policing authority at a different time. Now, if we start by looking at how IEH put their claim on this, perhaps we can just turn to the pleading, which is the core bundle, tab 15, paragraph 36, which is page 300. And IEH put it in two different ways. The first way is the way that the judge preferred, and that's paragraph 36. Each interruption or interference with each of the claimant's businesses carried on in each of the premises constituted a separate claim with its separate limit of indemnity of £500,000 and an indemnity period of 3 months. The second way it's put is indeed the way that we would accept it, certainly as we understand the pleading, that it is a composite policy, that is to say each insured has a separate claim, and it refers in paragraph 37 reading down as each claimant had a separate interest represented by the premises which it owned or operated and which it had an insurable interest. Accordingly, the limit of indemnity of £500,000 and indemnity period applied to each individual claimant, respectively. So the alternative case is the case that we say is in fact the correct one. And even going back to paragraph 36, we essentially accept the first part of what IEH say, i.e. the claim is by reference to each interruption or interference with the claimant's business. We'll come to businesses in a minute. But what we don't accept is the characterization that the clause necessarily limits that, or necessarily provides that a claim is to be assessed by reference to each premises. Now, what one can note here, and I'll come back to this, is it's no part of the claim, no part of the pleaded case that the claims operate per incident. I'll come back to that. If we can turn then to the language of the clause, which you've obviously now seen a number of times, which is its supplemental bundle, tab 2, page 131. And we see there the first sentence starts, any claim resulting from interruption of or interference with the business, capitalised, I'll come to that, but that's the business of the insured, and then the rest of the clause. But the reference there is to interruption of or interference with the business capitalised. Now, before we get to the question of definition, it's obviously right to say that if an insured had multiple premises, one would foresee that there might well be central costs involved by any of the individual premises being affected. So in the context of a theatre, I think the example given below was that if one theatre was closed, there might be central costs in terms of having to deal with rebooking of tickets, etc., perhaps seeking to rearrange the performances to another theatre if it was possible, but not necessarily all related to an individual premises. They might have an effect on the business more widely, and not just the individual theatre. And that's why we say it doesn't necessarily make sense to talk about the business of a premises. If a business has multiple premises, you're actually looking at the business as a whole. Now, the extent of the connection between premises will obviously depend on the type of business and their location. But overall, one will always expect there to be central costs of the business. If we then turn to the actual definition of business, I've given what one would expect a business to include, one finds, we say, support for how it's been defined. So if we turn first to page 1 of, tab 1, page 2. And we see just over halfway down policy definitions, business, the business description stated in the schedule. If we then turn to tab 2, page 115, we see there, and I think my learned friend took you to this yesterday, the business description overall, theatre, cinema, concert hall, etc. And if we turn on in the schedule, we see that this is restated. Again, I think my learned friend pointed this out. At clause 122, in the middle, S26(1), business description, full description is as stated below. And the point to note there is business is not defined by reference to the premises. Now, if we turn to the business interruption section of the policy, which is back in tab 1 at page 43, and we look first at business interruption, we see loss resulting from interruption of or interference with the business carried on by the insured at the premises in consequence of an event to property used by the insured at the premises for the purpose of the business. Now, it is right to say here that the second premises is capitalised. The first use of the word premises there on the second line is not capitalised. In my submission, it clearly is intending the capitalised form, the defined form, because it doesn't make sense for them to mean different things. And we can be reasonably confident that that's intended, because I think, as my learned friend pointed out yesterday, there is a separate provision for estimated revenue, which is almost in identical terms, my learned friend said, which is on page 57. One just turns to that. And certainly there, the reference is, and I accept it's not, we'll see some differences, but the reference there is certainly to business carried on by the insured at the premises defined. We'll come to the definition in a minute. So we say that it's sufficiently clear that although the first reference to premises there isn't capitalised, that must be what it refers to, the capitalised if one then goes on to the defined term of premises, one sees the definition being the buildings at the address or addresses shown in the schedule. And for present purposes, that we say makes clear that the policy assumes that the business may have multiple premises. So when premises is being referred to, it is referring to all the premises of that business. Now I should say, the schedule does not in fact provide the address of any of the businesses, as often one finds a slight disconnect. What one has is the address of the postal address of one theatre at page 115 of the schedule for the insured, which is in fact the holding company. But in my submission, that can't make any difference either way. I mean, it's a problem in a way for both parties. Clearly, there is cover here. We're not suggesting that the insured doesn't have cover because they didn't put their address in the schedule for purposes of having a stated premises. What it must mean, looking at it overall, is what would be the addresses of the relevant insureds, whoever they may be. And it might be my suspicion that would be the natural reading. If we then move on with the definition, we see that the reference to, if we turn first to turnover, on back to page 43 of the definition under business interruption, we see turnover is defined as the money paid or payable to the insured for goods sold and delivered and for services rendered in the course of the business at the premises. So that quite clearly there is referring to the premises, not just premises singular or each premises, it is there collectively. So one's not looking at each theatre individually, one's looking at them collectively. And one sees then that the definition of turnover is then referred to in the other definitions, such as gross profit and over the page rate of gross profit and standard turnover, all of which go into calculating what the business interruption loss is. And we can see how it feeds into the final calculation of the claim by turning on to page 48 of tab 2, where it sets out the basis of settlement. At the top, the insurer will pay the insured in respect of each item covered the amount of their claim for the business interruption, and then it sets out the calculation. If we jump down to the middle, the insurer will pay to the insured as indemnity in consequence of business interruption for loss of gross profit due to a reduction in turnover and increase in the cost of working. And then it sets out precisely how that's calculated. So it's using the definitions that we've seen, which themselves refer back to the defined term of premises, which is premises plural, as opposed to looking at them individually. Now, IH say in their skeleton that we have ignored a key clause, the alternative premises clause, and they say that this clause indicates that our assumption is wrong, and in fact one only looks at alternative premises or broader premises and very specific purposes. The alternative premises clause can be found at the bottom of page 48. One sees it there. One alternative premises: if during the indemnity period goods are sold or services rendered elsewhere than at the premises for the benefit of the business, either by the insured or by others or on behalf of the insured, the money paid or payable for such sales or services shall be taken into account in arriving at the turnover during the indemnity period. But again, this is using the defined term premises. So what it's saying if you are carrying on business at a premises, not one that you own, not one that's already part of the business, that you've hired somewhere else, you've got some other place where you can have your theatre performance, or if you're a restaurant, open up elsewhere as a pop-up, then you need to take that into account. It's not dealing with a case within the business, and it would be very odd if because that's already defined within the scope of what the of the loss of profit. Because you're looking at the business of the premises. You're looking at the premises as a whole in terms of calculating the business interruption. So you don't need to. So we say far from undermining our point, it's consistent with the general point that what the business interruption policy is doing is looking at the overall impact of any interruption on the business as a whole. When it comes to the interruption in relation to other premises, the ability to move, for example, let's say you had a performance that couldn't take place at one theatre because it was closed, because the road was closed, you might be able to move it to another theatre which was empty and which wasn't being used. And it would make no sense to look at the profit of one part of the business without also taking into account the other part of the business. That's already inherent in how you calculate the loss of profit under the policy, because you're looking at the premises as a whole. If in fact you were to rent new premises for your theatre production, which couldn't take place, then the alternative premises clause deals with that situation, and again, you need to take that into account. We also rely, albeit we don't try and put too much weight on it, the fact that there is a specific provision in relation to the deductible, which again operates on the basis that one premises may be closed per claim. Now, if we look at page 122, SB tab 2, page 122. And it's clause S36(1), which is 2/3 of the way down. Property damage, business int excess. Property damage, business interruption excess equals £5,000. Each single occurrence where the insured has made a claim for a single property loss and or single business interruption loss affecting one or more insured locations that arise from or attributable to or in connection with the same single occurrence or retention, etc. Again, presupposing that they are dealt with together. Now, the point's made, and it's a fair point to make, which is that this clause, like some others, appears to use terms which aren't elsewhere defined in the policy. And I accept that, and I, again, accept the more general pick and mix point that there is a danger of trying to take too much from different clauses which clearly haven't been drafted together in an altogether coherent way. And I equally accept that a deductible does not need to work the same way as a limit. But what I do say is, absent something express, the reasonable policyholder would expect the same approach to apply both to deductibles and limits. They're different sides of the same coin. Now, turning to how it was analysed and how my learned friend puts it in the skeleton, significant weight was put on the fact that there were separate incidents, or there would be separate incidents in relation to each of the premises, and the fact that there are separate incidents giving rise must, it is said, suggest that they must therefore be treated as different claims. And the point that we make is not that incidence is not relevant to the analysis, but rather that the clause does not, and the claim does not respond as such on a per incident basis. And indeed, you've seen that that's not actually how the claimants put their case, and we say quite correctly so in the pleaded case by reference to the interruption. So if one takes an example, let's say one has two road traffic accidents, separate road traffic accidents, on the same road at around the same time, and as a result of which the police turn up at the same time and close the road. Each of them could have closed the road, but they've turned up at the same time to close the road. We would say that is a clear example of there only being one claim. Why? Even though there are two incidents, two different road traffic accidents, because there's only one restriction with the immediate result of an overall interference with the business. It's the same restriction, it's the same closure which is being applied at the same time. And in the COVID context, one can translate that to saying it makes no difference whether you are shutting the individual premises, focusing on the individual premises, because of one case of COVID or 1,000 cases of COVID. There is a single interference with the business which has been brought about by the government restriction, the single government restriction at the same time to close. And simply adding the instance doesn't add claims. And again, that's never been suggested by the claimants, and quite rightly so. And I also accept the other way around, and it's a point that my learned friend makes, that in principle a single incident could give rise to two claims. So if you have one road traffic accident which would affect potentially two premises, two separate premises, you might have different restrictions of access. There might, for example, be two separate policing authorities, maybe on a border, who take different approach to restrictions of access. In that case, again, one would say, well, actually, although there's been a single incident, that might give rise to separate claims. Here, we say there will only be one claim as there is a single overall interference with the business at the same time for the same reason, i.e., on this assumption, the policing authority being government, by way of the March regulations.
When you say a single incident could give rise to two claims, are you including in that or excluding from it, say, a case where there is a single road accident on quite a scale, which causes a number of roads to be closed, affecting two theatres located in central London?
The difference, the answer is that could be two claims. It depends on whether you have separate prevention of access, we say. That's the core. Is there, as a result of this, a different reaction by the policing authority? The most obvious ones are where you have different policing authorities which take different action. So let's say one was within the City of London and one was within Westminster or the Metropolitan Police, and they take different views to restrictions of access. That single incident may give rise to different non-unitary effect on the two businesses, which is not the same.
But if it's a single policing authority, it's in the West End.
Yes, if it's done once.
And it affects two different theatres located close to where the accident happens, then you say that's a single claim.
And the reason, and what we say, the focus is, because I've shown your Lordship, obviously, the aspect of the clause we say is referring to the business as a whole. That's the context, interference or interruption with the business as a whole. And the core element we say, when one looks at it from the reasonable policyholder's perspective, is the notion of, is this a single interruption? Is there a single reason behind this? Is it happening once? And the answer is, in the case of the COVID example, or in the example of a road traffic accident which ends up causing two theatres, closing two theatres because the entire area is closed, is that it's the same. It's the same interruption with the business. It's the same. If one's asked about what's the immediate cause of the interruption in the business, the immediate cause of the interruption with the business is the policing authority's restriction of access. And that's the case even though it restricts two premises access, I accept that. But the key element we say is the fact, that it's a single restriction. And obviously that then translates into the COVID scenario, where we obviously say, if you have a single reaction by government, on this assumption of government being a policing authority, or Matt Hancock being a policing authority, to all the incidents at the same time, that's probably to be regarded as one claim. Why? Because the claim arises out of an interruption or interference with business, which is the business of all the premises, as an immediate result of the policing authority, here the single government authority, Matt Hancock, taking one action. And it's artificial, you could say, not how a reasonable policyholder would read it, to say, actually, that is a whole series of separate claims.
But what about the distinction drawn between different areas subsequently, where different areas had different restrictions imposed?
And those would then be different claims. So as soon as you have different restrictions, I would entirely accept, so the Leicester example, then you would have, it would no longer be the unitary government reaction closing down preventing access.
In the example you've given of the two different authorities closing down two separate theatres, does that mean if it was Constable A that shut down one theatre and Constable B that shut down the other, which doesn't strike me as all that fanciful actually, that would be two different policing authorities?
Well,
two different interruptions.
The answer would probably always be a question of degree. If it is substantially the same closure, I can see the argument simply being no, that would be regarded as being one. If there are different, if it's a different form of access, so for example, one could see, it's important to understand that this doesn't require the actual closure of the premises. We're talking here about restriction of access. Okay. So you could have a situation where Theatre 1, for example, is completely closed down because you can't get to it, because all the roads are being closed off to get to the Savoy Theatre. By contrast, Theatre B, and I'm not very good at my theatres just around there, but the Adelphi, maybe, one still is able to access, albeit only on foot, with the result that fewer theatre goers are able to come to the performance. Those would be separate restrictions. And the key element and the unusual, and I accept, that's why I started by saying, I accept that in practice, this clause will typically end up responding on a per premises basis. The question is whether this clause is intended to operate per premises, even though it doesn't say so as such, in the very unusual circumstances of the COVID pandemic, where in fact there was, on this assumption, a single authority, Matt Hancock, providing a single restriction on access, which was in fact the same for all the relevant premises. That's the distinguishing, and I entirely accept, very unusual set of facts that we have here. As soon as you have different forms of authority carrying out the function, or different forms of restriction, then I accept that won't apply.
So in the lockdown, there was considerable press coverage of the fact that certain police forces were taking certain action that others weren't, that they were more robust or not sufficiently robust or anything like that. And one can think of situations where there are more than two police forces. And you're saying that if we'd got that situation, I'm thinking about the City of London Police as opposed to the Metropolitan Police. So if they'd taken a different response to the same major accident, unless they were for different reasons, only one premises would be covered and not the other?
No, again, if they're taking different action, the restriction would be different. It wouldn't be the same unitary restriction. That's what's so unusual about this situation, is you had a national restriction on all theatres, whether you were up in Manchester or down in Southampton or London, which affected, as a theatre, meant you had to close. And so in this case, there simply isn't that distinction. As soon as one moves away from that, and one starts saying, well, different local authorities had common approaches, but weren't actually the same, then I accept it will almost certainly be into separate claims per premises. Why? Because the restriction on access won't have been unitary, won't have been a single clause. So one can't say that the immediate cause of the interruption to the business was the same. That is the distinguishing feature that we rely on here, which is that where you have the immediate cause of the interruption to the business, which is how we say one should look at the claim, and which is how the claimants put it, albeit they go on to say, well, I should add on per premises. When you look at it that way, we say you end up inevitably having to focus on, is it the same interruption, is it the same prevention of access by the policing authority or by a policing authority? If it's a different policing authority or it's a different form of restriction because there are local restrictions, then it won't be the same. So this applies where it is the same, where you can simply say that there is no distinction being drawn. What was the immediate cause of the prevention of access, which led to the interference with the business as a whole, i.e. all the premises? It was on this assumption, the 21st March and the 26th March regulations.
So it's on the basis that the Secretary of State for Health was a policing authority.
It has to be.
That's the only basis of your arguments.
Yeah, that here we're talking about a single authority. So
yes.
This is on this. My learned friend succeeded. Obviously, we hope
yeah.
to
So
be here,
on the basis that that was a single authority, regardless of how it was interpreted by others, you'd say that's a single claim.
Well,
but if that single authority resulted in different police forces taking different actions, it could be more than one.
yes, I'd accept that. But here, because it was binary, they just had to close. That issue doesn't arise. I accept your ladyship's point would apply in circumstances where effectively there's some form of discretion as to whether they should be open or not, and some authorities take the view, no, you're all going to be closed, and others are saying, no, you could operate at 50% capacity or something. That would clearly be different forms of restriction of access. One obviously would have the argument as to who is the relevant policing authority there, whether it really is the government or in fact whether it is the local authority on that analysis, which would seem to be even my learned friends. But this is the point. But this is all on the basis I've lost on what policing authority means. I have to assume here that policing authority means central government to Mac Hancock, because otherwise we're not here. I have to have lost on incident and I have to have lost on policing authority. Right. And of course that is maybe part of the reason why all this part becomes quite artificial, because we say if one interprets it more narrow, these sorts of problems won't arise because it just wouldn't be dealing with these sorts of issues in practice. But given that on the assumption we're at, then we say that is how most reasonably a person looking at this would say it would apply. It can't be incident for the reasons I've indicated. That can't be the key feature. Premises are relevant, we say, not because of the fact of them being per premises, but rather that typically you will end up with different restrictions or effects on those premises. And
premises is relevant just because there's a 1 mile radius. Isn't that the simple reason why the premises
yes.
is always relevant? Because if a set of premises were closed where there wasn't an incident or an effect, doesn't matter who's right about
yes.
that, within the 1 mile radius of a given premises, then the clause doesn't apply
yes.
to those premises.
Yes, that's correct. So it's right. You still need to satisfy that element of it. So it's also a point that can be made is, well, you still need to, the 1 mile radius still applies.
Well, doesn't that tell you that the clause is thinking in terms of premises? So an interference with one premises is one 1 mile radius, and an interfere with another premises is a different one.
Except that the claim is for the interruption of the business as a whole. So business is defined as all the premises. But again, as my learned friend said yesterday, it's not a case where I'm saying I can't understand how you can reach a different conclusion. I'm simply saying that if one focuses on the words that immediately follow claim, here interruption and interference, and in particular defined term business, which is a collective of all the theatres on this analysis, and then follow through to say, well, actually, how do we distinguish between what is one claim or multiple claims? In my submission, the key element is the nature of closure. Are we talking about different closures, different preventions of access, or, as we say, it is really the immediate result of the closure because of a single the immediate cause, singular, namely the government restrictions by Matt Hancock.
Could I ask for your assistance on this then? So, go beyond the first set of restrictions where there were different areas designated for lockdown effectively or for more liberal association between the general population. On your analysis, wouldn't it be right that if any one of the businesses of the insured was affected by an incident within a mile radius by reason of restrictions because you'd lost on that, then that means that the business as a whole could claim for knock-on effect because the reputation of closing down one theatre might mean that theatre goers say, well, we can't rely on IEH to come up with the goods, they'll take any excuse. I mean, is that what you're saying? That would apply?
No, I'm not saying here, because actually if one looks at the clause itself, which is back on page 131, as often in this case, premises there is not actually defined as capitalised. So I'm not saying that the 1 mile is by reference to any of them, and it's therefore that's sufficient to satisfy any claim. I am, as I think I was answering to my Lord Justice Birss, saying that you do still need to satisfy, essentially, tick off, is there an incident in relation to each of the premises for which you're trying to seek any loss at all. But when you're then doing the calculation of the loss, you are taking into account the overall position. And the overall position may be pluses or minuses. There may be theatres which are doing particularly well because of others being closed. So you take that into account. And so that's how we say this clause should be approached. And why sort of the examples given of, I don't know, gas leak in Manchester and I think car accident in London was one of the examples given, aren't any difficulty, because we clearly accept those sorts of examples will simply give rise to different preventions of access, or the riot in London and the terrorist attack in London. Again, different forms of closure, which will clearly, we would accept, be different types of claim. As I said, the unusual, unique almost, well, I think probably is unique, feature of the COVID pandemic has been the national effect of the regulations on all the businesses at the same time, and on this assumption, one that falls within the scope of the clause. And the question is therefore how, looking at how this clause is phrased, would a reasonable policyholder divide it up? One way is to say, well, it's per premises, and my submission as to why that's not the case is actually that the focus on that case would be looking at what the cause of the closure. I mean, what is this? This is a form of denial of access cover, and the denial of access is the same single denial of access to all the businesses, all the premises within your business. So that's the point that we seek to make, and to use that, I think, to deal specifically with the nuclear example that I think was given of one incident affecting 2 different radiuses. I mean, that would be a similar point where we would accept if it's the same closure affecting 2 premises, it would be one claim. If they're different closures,
one incident. You're saying one.
This would be a one incident claim, but I think one of the examples what was being made is that would be an example of there being 2 claims being made because you'd have 2 premises affected. And my submission would be no. In that situation, you would have one claim.
Because it's one incident.
Not because it is one incident, but not because it's one incident, because it's one closure, it's one effect. Because I accept, as I was indicating earlier, you can have a situation where you have one incident, one car accident where you have different reaction by different policing authorities, for example, to the same incident. And in that case, there would be different restrictions, and I would accept those would be different claims. That's the distinction. The focus of my submissions are on looking at the business as a whole, for the reasons I've indicated on the submissions, and then focusing on what's the immediate cause of the interference. The immediate cause of the interference is the closure, it's the restriction of access, in this case the actual closure of the theatres, as a result of which all of the theatres were affected in exactly the same way. My lord, my lady, or my lady, my lord, the IEH and the judge relied on on the Corbyn and King decision in this regard, and if we could just briefly look at that. This was another non-damage denial of access clause, but with rather different language. That's at Authority 6 as Bundle 1. And if we start at page 195, and paragraph 228, Mrs. Justice Cockrell introduces the argument, 228, and says there are two strands to the argument, the wording of the policy and then the question of whether it is composite or not. She then makes clear that actually it makes more sense to start with whether the policy is composite or not, so that most of the reasoning relates to the question as to whether it is a composite policy or not in that case. And she concludes that it is a composite policy, i.e., even though each of the insureds, plural, of the policy have their own separate interests, and in this context, she ultimately includes their own limits. So it's treated as though essentially there are separate contracts of insurance with each of the insureds, so they get the benefit in that way. That doesn't necessarily mean, as Mr. Justice Cockrell points out, that you could have an overarching limit for all the insureds, but she makes the point that the starting point is you would then assume each one would have their own limit, and that's her starting point. And here, of course, that initial argument isn't an issue, because we accept that this is a composite policy. So for each of the insureds of the various, most of these insureds own an individual theatre, some of them own multiple, they each have their own limit which applies. So that's accepted here. But Mrs. Justice Cockrell went on to deal with the point of construction more generally, and one can pick that up at page 197. And perhaps just one notes that at 237 to 238, one can see there her conclusion that it's a composite policy, and at 238 it's not an insignificant conclusion, because although it's not beyond the bounds of possibility that there could be a composite policy with a single limit which applies to all the premises and all the claims, that would certainly not be the expectation in the context of a composite policy. And I should say again, just for clarity, the position in Corbyn and King was that most of the insureds owned only one premises, but there was an exception, and we can see the exception at footnote 5. There was one cafe, the Cafe Wolsey at Bicester. It and the cafe restaurants, the Sooty and the Bellinger, were owned by the same company. So there was one example there before Mrs. Justice Cockrell, albeit she doesn't explore that difference any further later. But at 239, she introduces the sort of contractual construction points that she considered were the most powerful for supporting the point that you should consider the losses on a per premises basis rather than on a sort of per insured basis. Or indeed, in this case, on an overall basis, which was the primary submission by insurers, that there should be a single limit across all of them. And the first point she makes is the wording of the policy. And under 239 sub 1, she relies on the fact the policy refers to cover in respect of, and it's important to look at this, interruption and interference with the business where access to your premises is restricted. So one can see there It doesn't appear as though business there was a defined term. We haven't had the arguments. The arguments that are put here don't appear to have had any role in Corbyn and King. But more particularly, there is a link there between the business and the business where access to your premises is restricted. So one can see the argument there that this policy is linking the business to the specific premises. Whereas we say on our definition, because business applies to all the premises of the relevant insured, that doesn't apply. So that, we would say, is a material distinction in terms of how the language is put. And just, for completeness, I think you may have been taking this before, the full policy wording is at paragraph 14 at page 158 of the, 156 of Corbyn and King. One sees it there, denial of access, non-damage, full word. We will cover you for any loss insured by this section resulting from interruption or interference with the business where access to your premises is restricted or hindered for more than the franchise period shown in your schedule. So that's the first point, and we say the wording here is materially different. It's not just that the wording before Mrs. Justice Cockerell pointed to linking the business with the premises. We say it's not that it's neutral here, it positively points the other way. The second point that Mrs. Justice Cockerell relied on was a broader point, and it's, I won't read it out, but perhaps if you read it, it's sub-paragraph 2, but it's the notion that different premises will be affected differently.
Subparagraph 2 of
Sorry,
paragraph.
239 sub-paragraph 2 on page 197. A point on this is really not that there may not be commercial reasons to consider that premises may be affected differently, because they might, but equally there are multiple other factors may be relevant. I mean, for example, I think below one had the discussion that some of these theatres, I think the Savoy Theatre may only have 450 seats, or maybe it's the Ambassador Theatre, whereas the Playhouse in Edinburgh has 3,000 seats. One could go into a level of detail on each of these cases and say, well, actually, there should be very different limits for each of these theatres if it's going to be on a per premises basis. And you can have all sorts of rationales as to why you would or wouldn't do something. But in my submission, the reasoning given there is not itself a powerful reason to decide whether this is per premises or not. That is really to be answered by simply looking at the wording. The commercial rationale for whether it makes sense to insure premises separately or to have higher or lower limits is really an entirely different discussion. And in my submission, there's a sort of danger of entering into that sort of speculation as to why parties may have chosen a very low limit to do it altogether by insured to seek to restrict their exposure. Alternatively, they may choose to have a very high limit. Trying to speculate the reasons in my submission is not of assistance because a bit like with 25-mile radii, etc., there are always going to be arbitrary limits in policies, and it doesn't assist one way or another, we would say. And we draw some support, I mean, not, from what my Lord Justice Mayle said in the various eateries case in that regard, where a similar submission was made on behalf of various eateries, that in fact this passage in particular was a factor in how to construe a aggregation. Again, I accept it. It's very different wording. I'm not trying to say that it necessarily applies from one to the other. But what I do take from it is the notion that there isn't an independent, powerful factor that somehow, as put, means that there can only really be one result. You can only really sensibly view it as per premises. That is going too far. The focus must be on the wording in each case. And
is it excuse me? Is it a relevant consideration in our policy that most of the premises insured are insured on a per premises basis because they happen to be owned by a company which only has a single premises. And can one say that it would then be surprising if a different regime were intended to apply to those which, more or less fortuitously, happen to be in multiple ownership?
Well, I think the answer to that is because we don't have before the court, and no one's ever sought to argue, the rationale for how this was insured. That would be a dangerous approach. I mean, it might be, for example, I'm not saying this on the basis of anything at all, but just speculating what the answers might be. The answers might be, well, we've grouped together a lot of small theatres. And so, although, some of them look bigger than others, in fact, they are, some of these only have 400 or 500 seats, these ones have 2,000 seats, or these ones are mainly in London, which will have a certain sort of exposure, and they're mainly on their own, whereas these other ones are in the provinces, and the exposure is likely to be lower if there's a problem. I mean, there could be all sorts of rationales put forward, and therefore assuming as to why, and I genuinely don't know what the answer is as to why the approach was taken, but that applies equally to why weren't there separate negotiated limits for the different sizes of theatres? Because if it's right that it's per theatre, one might say the real question starts becoming, well, why are you insuring a 400-seat theatre in the same way as you're insuring a 3,000-seat theatre? And they're not points that this court can answer, and certainly not ones I can answer. And it is the reason we would say that one should therefore be cautious in trying to approach it on that basis.
Thank you.
What would happen if it was the head office that was closed, which didn't have a theatre in it? Does that make any difference?
Sorry,
if it was the head office that was closed rather than any individual theatre, would that make any difference to the analysis?
In terms of what? As in whether that would suggest that it should be, it would encompass, it would be per premises. I would suggest not, because in each case one is looking at what the effect of the closure as a whole. I mean, in terms of my analysis, the analysis is simply one is looking at the closure as a whole. And as soon as you get into individual effects on different premises, so that, for example, you can go into your head office, but you can't go to theatre, that type of issue becomes a different argument. But here we're just talking about the theatre. The theatres, that's the focus of the. So, in answer to the judge's point, which is that we're seeking to find aggregating language that's not there, we would respectfully say that what we're doing is we are seeking to construe how this clause would be applied in unique circumstances, where obviously our primary submission is we'd never get here, that if we are here, how would a reasonable policyholder understand it in circumstances where, slightly picking up on the way my learned friend was seeking to put the argument in relation to effect, whether inside or outside the radius, one starts with the initial wording. The claim relates to the interference with the business. That's, we say, is the focus. That's if the policyholder would understand that's the relevant question if they read through and see business includes everything. And what's the is it a common restriction or is it a different restriction? And if it's the same, we would say restriction because of a single government instruction or regulation, the 21st March and 26th March regulations, then we say that provides the answer. That's probably a good time. That's all I was going to say on ground 2, and ground 3, I can promise, is very short.
All right. So, 2 o'clock?